back with Bruce Olson, president of ONLAW Trial Technologies, for part 2 of our sessions on electronic and computer forensics evidence. And Bruce, what basics should a lawyer know about how information is electronically stored?
Well, a lawyer should understand from the get-go that information that's stored electronically is volatile information and can easily be lost or altered by any number of means. It can be altered simply by booting up a computer. It can be altered simply by opening up a Word document, reviewing it, and saving it. So in order to preserve information, which is typically what everyone wants, they want the information as it existed at the time of whatever's involved in a particular piece of litigation. You want to get in early to be able to preserve the information and keep it from being altered. Great.
Now, what are some examples of electronically stored information, I guess it's called ESI, that attorneys don't necessarily think about?
Well, the typical things that you would think about, obviously, are word processed documents, spreadsheets, photographs, email. Those are the predominant items that you would be looking for. But in terms of the business world, we find many other types of applications that are out there that create electronic files that we might need to look at. These could include architectural design drawings. It may be video files that have been created, maybe even things such as YouTube files that people are creating. Social networking is another area where information is being created on the computer that's used to access and upload information to the social networking websites.
So here's I guess the question that most of us are thinking. You know, is this really as electronically stored information in computer forensics and electronic discovery? Are these issues that really only litigators should be concerned about?
No, actually, it's not true that it's only litigators that have to worry about it. And the primary reason is that there is recognized in the law a duty to preserve information when there is a reasonable expectation of litigation, and that can happen long before a litigator is involved in a case. You may have a transactional lawyer that realizes a deal is going south and they need to inform the client to take appropriate steps to preserve information. It could be in a domestic case. There are many other areas of law other than something that's into full-blown litigation where you have to have knowledge of the basics of the law relating to electronically stored information and e-discovery in order to avoid committing malpractice.
Well, Bruce, thank you. And that brings to a conclusion this episode of Practice 411 Fast Lane on electronic and computer forensics evidence. Join us for the 3rd and final episode in this series. Thank you.